My name is Chuma Chinye, and I am your family lawyer. I was called to the Nigerian bar in 1988, and I have over 35 years' experience in family law practice. I've helped countless families navigate Nigeria's complex legal terrain, and I am desirous of bringing this knowledge and expertise to you free of any charges. My name is Chuma Chinye, and I am your family lawyer. I am your go-to legal expert, always here to help you untangle the complexities of family law. Today, we'll dig deep into spousal joint property ownership, which is at the core of one of the most thorny issues in contemporary marriages. We'll attempt to simplify the concept and the intricacies of joint property ownership in marriages. We'll attempt to help you to understand the legal consequences of the choices you make regarding what you own individually or jointly as a married man or a married woman. And whether you're newly married or you're a veteran, you have been together for years, this episode is packed with valuable information to guarantee your happiness from the beginning until the end. So let's get started. Let's kick this episode off by answering the obvious question. What is spousal joint property ownership? In plain language, spousal property joint ownership refers to a type of property ownership where two spouses, that is to say, a husband and a wife, jointly own a property, typically a home or other real estate. This means that both spouses have equal rights and interests in the property and are jointly responsible for its maintenance, expenses, and liabilities. But what about properties acquired by each spouse before marriage? Generally, the law is that these properties remain the separate property of the individual who acquired them, unless they are explicitly converted to joint property through a legal agreement or by the actions or inactions of the parties involved. When divorce knocks, though, it's a game changer. It's a totally different ballgame. Because when the court is called upon to undertake settlement of property post-divorce, a spouse, well, typically a wife, doesn't always need to have contributed any money in the acquisition of a property before it can be attributed or awarded to him, or indeed, as I just said, typically to her. In Nigeria, owning joint property as spouses can have both advantages and disadvantages. That's why I'm here as your family lawyer, to give you a balanced view of what is not, what should be, and what should not be. First, let's talk about what is good about joint property ownership. In truth, it fosters unity and cooperation between spouses, promoting a sense of shared responsibility and oneness, and even teamwork. Joint ownership can provide economic stability and other benefits, such as shared financial obligations and reduced stress, and even taxes. Joint property ownership can simplify inheritance and succession processes, ensuring that the surviving spouse inherits the property without family wahala, external family wahala, that is. Joint ownership of property can provide emotional security and a sense of belonging, strengthening the ties of marital bond while it lasts. But it's just like roses, actually. It has thorns, not always smooth and easy sailing. So let's flip the coin and take a look at some reasons why joint property ownership might not be as rosy as the picture we just painted. Joint property ownership can lead to disputes and conflicts between spouses. Of course, you know how it is. Particularly if they have different financial priorities or management styles, that is to say, financial management styles. Both spouses are jointly and severally liable for the debts that they may incur for that property that they own jointly, and indeed for every obligation that is related to that property. And this can be a significant risk to take if your one spouse is not as responsible or as committed as the other. And joint property ownership may require the spouses to obtain each other's consent before selling or disposing or otherwise dealing with the property. And this can limit flexibility, particularly if one spouse is unreasonable. And this often happens. In the event of a divorce, joint property ownership can complicate the division of assets and may lead to very serious disputes as to who owns what and who should get what. But does this mean that it's not a desirable thing to do? It is indeed, and can actually be very desirable if both spouses have a good understanding of each other's financial goals and priorities. If they are committed to the oath of marriage that they took, if they have a clear agreement on understanding, outlining their rights and responsibilities, if they have good legal support, and if they are reasonable persons, and they are willing to work together to manage the property and resolve the disputes if they arise. And again, if they do understand the potential risk and benefits of joint ownership before they go into it, it will guide them and help them to minimize or avoid those conflicts. Ultimately, whether you want to own a joint property and whether it is desirable depends actually on the individual circumstances and the dynamics of your relationship as a couple. It is essential for spouses to carefully consider their decision and seek professional advice before they leap into joint ownership of properties. I will now attempt to lead you through one of the most significant aspects of joint property ownership in Nigeria, and it is joint accounts. In our country, having a spousal joint account is one of the most common features of joint property ownership, because even couples who do not own or have real estate can keep and manage their funds mutually in one account. This can be beneficial, very beneficial, but it's essential to weigh the pros and the cons before making a decision. Trust me, you know truly that I will give you a balanced view of how this should work or not work. Again, I will lay out for you what are the advantages of owning a joint account, and I will show you the downside so that if you are going to do so, you are well informed. Joint accounts can simplify financial management, allowing spouses to easily track and manage their shared expenses. It could promote transparency, as both spouses can view account activities and balances easily without hindrance. With a joint account, it is easier for couples to plan ahead for house rent, for school fees, for holidays, and even for care of their elderly parents. In the event of a spouse's death, the surviving spouse can easily access and manage the joint account, even for funeral expenses and for life thereafter, without needless interference and without needing to apply for probate or letters of administration, as the case may be. But this is what I can say for how good it is. It does have downsides because both spouses are jointly and severally liable for debts, for overdrafts, and for loans on the account. And joint accounts can limit individual financial autonomy because both spouses may need to consent to a transaction before it can be done. It could create disputes if spouses have different spending habits or financial priorities. This is perhaps one of the biggest drawbacks of a joint account, and I'll tell you why. If the husband is a spendthrift or a gambler, there's wahala because he will fritter all the money away. He will wreck the family, and the wife will be left on a cliffhanger. This is more disturbing if the wife earns more than the reckless husband or contributes substantially to the account. It could even be double wahala if he's a womanizer. How will he fund the philandering activities and the several ventures that are involved with that venture? We know how very expensive that business can be. Very expensive. On the other hand, if the wife is a shopaholic and loves to buy newborn straight hair, or frequently is involved in the Ashwebi Saturday to Saturday venture, wahala no go finish for that house because while the husband is gambling or while the woman is shopping, there will be nothing left for the children. So you need to think twice if any one of you has this tendency. But it's indeed desirable to have a joint account because both spouses will have a good understanding of each other's financial goals and priorities. If they have clear agreement outlining their financial responsibilities and expectations, and if they have the discipline to stick to it, it is indeed very desirable to run a family joint account. If they are willing to work together to manage the account and resolve disputes the family way. If they understand the potential risks and benefits of a joint account, then it may be a worthwhile venture. But ultimately, I must tell you, whether a spousal joint account is desirable depends on the individual circumstances and the dynamics unique to that couple. It is essential for spouses to carefully consider their decisions and, where necessary, seek professional or legal advice before they go into running a joint account. The minimum you should do is talk to your banker. Now, let's make it take just a little bit of technicality and explore the legal implications. First, there is something that's called tenancy in common, and there's something called joint tenancy. When we talk about tenancy in common, it simply means that each spouse owns a specific share of the property that they own jointly. We own a twin duplex. Wing A is mine, wing B is yours. It is well known, and which means I can sell my wing and whilst you keep yours. In contrast, joint tenancy means equal ownership. In other words, two of us own that building together. It is not demarcated in any way. And the advantage of this is that when one spouse dies, the other one automatically inherits the share of the other person. Now, when disputes arise, there are, outside the family, there are some legal pathways to resolving the disputes regarding joint ownership of properties. The parties could seek out mediation, arbitration, and then if none of that works, they might end up in court. Of course, mediation offers a less adversarial approach because a neutral third party simply mediates between the two warring parties and seeks to find a common ground. Arbitration involves a neutral party who can make binding decisions on the parties if they subject themselves to that process. But of course, litigation, which is the last resort, involves a judge. It could be lengthy, it could be expensive. It could lead to, it's difficult to imagine a situation where a husband and wife in a subsisting marriage are in court over money. That marriage is dead on arrival. But before we draw the curtain on today's episode, let me throw a little hand grenade and ask a question that you don't want to answer. Is it a good idea to disclose all of one's income to your spouse? This will bring some of my gender folk to be quivering at the edge of their seats, and it will bring their wives' ears to be open wide so they can hear the answer. But calm down. Calm down. You need to calm down because the answer to this golden question is influenced by cultural, social, and individual factors. And here are some points to consider in answering this question. In many Nigerian cultures, husbands are expected to be the primary breadwinners, and they manage the family's finances, whilst the wives may not be expected to know all the details of their husband's income. In some social circles, it is common for husbands to keep their financial matters private, while in others, transparency and open communication about finances are invaluable. Let's be clear. From the time of our fathers until this, what is she bringing to the table generation? The male gender has been the provider. This male provider, who is a boyfriend, a dad, or a beloved husband, or a sugar daddy, is expected to always be available and be able to provide, even when the declared funds are visibly totally exhausted. And this is a fundamental part of what makes him the man, what makes him the breadwinner, what makes him the head of the home, and what adds sugar to the daddy is the fact that he's always able to provide. He's never expected by the wife, the children, and even the side chick to cross his leg whilst the house rent or the school fees are due, or when tires are supposed to be changed in the car. He must somehow find the money. Now tell me, how can he do this if he disclosed all he earned and it's already spent? Let me quickly exonerate myself. I'm not making a case for the man who hides his income from his family only to lavish the same on a side chick. I'm only just saying that if the man must always provide even when you know it is finished. You may cut him some slack if he keeps some aside for that purpose. Before we round up, we'll take you into a case that explores the settlement of joint property in matrimonial causes. Join me as we unravel this story of a former couple who found themselves navigating the complexities of property division. The family of Adewale Toye, whose journey began in 1970 when they got married at the marriage registry in Lagos. After 34 years, I didn't make a mistake. After 34 years of marriage, the husband got tired of the wife and decided to do away with her. She, in turn, filed a cross petition, also asking that the marriage be dissolved. And she asked for ancillary relief for the settlement of the property. The court obliged them. They didn't want each other anymore, and so the marriage was put asunder judicially. Well, the courts, both the High Court and the Court of Appeal, in reviewing this matter, relied on Section 72 of the Matrimonial Causes Act and held that the court had broad discretion in the settlement of property in a manner that is just and equitable, and awarded a property which was deemed as joint property. The Court of Appeal made a significant pronouncement, and that is why we're telling you this particular story. They said that there was no requirement of law for the wife to have contributed to the joint property. That is to say, the property that was owned by the couple or by the man. The wife does not need to have contributed money into purchasing it for her to benefit from it when they get divorced. The court went further to say that the contributions that the wife had made during the course of 34 years of marriage, even though not financial, they were substantial and invaluable. And therefore, that even that property that was awarded to her may not be enough recompense for her society and service for 34 years, for the children she bore, for the school runs, for the food she cooked, and the other room, of course. All of this put together enabled the court to say, look, madam, take this property after 34 years, you have earned it. So if you're getting divorced and you've been married for so long, you may need to think twice. That little nagging issue you don't like anymore, it may be best to bear it. If you're married for 34 years, you don't have too many more years left. So for long-term marriages, the necessity for just and equitable decisions is inevitable. Fairness and stability for both parties post the divorce is very critical. The woman who was married for 34 years is no longer spring chicken. If she was in service, she would have retired. Now, let's take a look at another case where the court looked at what happens to a joint property when one spouse dies. This was the case of Onya versus Nwaigwe, which was decided in 2021. And it involved a property that was located in Emene in Enugu State. Now, the persons who went to court were the children of a certain Sir Gabriel Onya, and they went to court against their father, claiming that that property in question belonged to their late mother, Lady Marcelina Onya, who bought the land upon which the property was built in her husband's name, and that she developed it from the proceeds of her business. The Court of Appeal, in looking at the matter and on the principles of joint property ownership, emphasized that in statutory law marriages, that is, marriages under the Act, the surviving spouse inherits the property and has the right to administer it. The court emphasized that the unity of marriage embodies the legal fiction that husband and wife are one, and that the death of one doesn't change it. It is 1 minus 1 equal to 1. And so the one that is left behind will inherit that joint property. But the court also noted that when you are saying a property is joint, in that sense, the court might have to look at what you brought to the table in the course of your marriage. And in the absence of such evidence, your claim for joint ownership may not be sustained. As we wrap up this episode, I would urge you to reflect on the things you've heard, these stories that we've told you, and let them inform your choices and the decisions you make as to whether you want to be involved in joint property ownership with your spouse. And again, it would be important for you to take a look at these things. If you are the throes of divorce and your marriage has been long, reconsider your position and live with your spouse peaceably, rather than go through the process of having to decide who got what after the two of you have been together for decades. Now, that said, so much for what the husband will do, what the wife might do with the money before disclosing, or whether I should disclose or not. But since I am your family lawyer, I should let you know the position of the law on disclosure of income by spouses, male or female. Is a spouse bound by law to disclose all of his earnings to his significant other? The answer is actually no. The Nigerian Marriage Act and the Matrimonial Causes Act do not explicitly require spouses to disclose their income to each other. Though the Matrimonial Causes Act governs the division of property, it is actually silent on this. It does not mandate income disclosure. Nevertheless, there are some contemporary personal considerations for which you might disclose your income to your spouse. For example, disclosing your income can foster trust and transparency in a marriage, whilst promoting a sense of teamwork and shared financial responsibility. Sharing income information can facilitate joint financial planning, budgeting, and decision-making. Note, however, that in spite of these considerations, some individuals might value their financial independence and might prefer not to disclose their income to their spouse. While there's no one-size-fits-all answer, it is essential for couples to have open and honest discussions about their financial situation and expectations and their goals and values. Ultimately, whether a husband should disclose all of his income to his wife in this country depends on the couple's unique circumstances, their cultural background, and their personal preferences. For our loving wives, just a word of caution. If you know all of his income and the money is spent, if you finish, you don't finish. Because you may also be sending that conscientious, hard-working man to his early grave by insisting that his income is our money and that your income is your money. It's time to go. We have given you a comprehensive look at joint property ownership in marriage, from what constitutes joint ownership to managing money in your home. Remember always that clear communication, financial and legal advice are key to navigating these issues. It's been my pleasure presenting today's episode of Your Family Lawyer to you, and I would like to think that's been a time well spent. Until next week, when we'll continue our discussion into how you manage your estate whilst alive for the purposes of your own comfort and for the future of the people you are leaving behind when you go. Until that Saturday, please stay informed and be empowered. And by all means, please be good to your family. My name is Chu Machinye, and I am your family lawyer.